Hey class, welcome to week 4. Today we are going to talk about agency rulemaking, which is the process by which agencies issue regulations. We're going to start with some real broad strokes because the topic is broadly applicable to all agency action. If you've taken administrative law, you already know about rulemaking, so this will sound familiar, but I want to go over it for the rest of class. And also the concepts from last week's reading on the Clean Air Act and the Clean Water Act, they're particularly relevant to this lecture, so keep those in mind as we go along. So today we're going to talk about rulemaking, what it is, why we care about it, a little bit about regulatory reform. But first, I want to say just a few words about the PETPO case that you just briefed. So one really good question I got was how we find the official citation for the case and how we know that that case is still valid, that the 10th Circuit's opinion is valid. So I gave you a PDF of the court opinion, but not the version that's in the Federal Reporter. So if you wanted to find the official citation, you would use Nexus Uni or Westlaw or Google to search for the case name, and you would get the Federal Reporter site, which is 852 F3D 990. Nexus Uni is actually a real good choice in this case because it allows you to shepherd-ize the case. So you can see here that Shepard's is showing that the case is still good law. It has that green positive symbol. You'll also see there is, and I'm quoting here, no negative subsequent appellate history. So what does that mean? It means that the U.S. Supreme Court decided not to hear an appeal from that 10th Circuit decision. We are going to discuss this later in the semester, not this particular case, but our court system, how they're organized. It's organized into district courts where the trials take place, 13 courts of appeals, which we also call circuit courts, and then the Supreme Court. So in this case, PETPO did appeal the 10th Circuit's decision to the Supreme Court, and a number of organizations submitted amicus briefs in support of that, including the Cato Institute and the Reason Foundation. Asking that the Supreme Court take the case, but the court declined. So what this means effectively is that the 10th Circuit's opinion remains law, at least in the 10th Circuit. Now, if another court rules differently on a similar case, it's possible that the Supreme Court will take up an appeal in order to resolve a circuit split, which is something that we will talk about later. I will get you your case briefs back as soon as I possibly can. I hope that you had a good experience writing them, and we'll talk about it a little bit next week. All right, now let's jump in and learn about rulemaking. So we start by asking, what is a rule? So, and as I've mentioned, rules are also called regulations. I will almost always call them regulations. That's my preferred term, and it's the term that most attorneys use. However, it's easier to talk about the rulemaking process rather than the process of promulgating regulations. So rulemaking it is. And if the word rule slips through in my lecture or on a slide, just know that I am talking about regulations. So the Administrative Procedure Act, the APA, defines a rule as whole or part of an agency's statement of general or particular applicability and future effect designed to implement, interpret, or prescribe law or policy as it relates to that agency. So what does that mean? Well, the main thing is that regulations are supposed to have the future effect of compliance. They direct future conduct, or they create a procedure moving forward. So like our laws, regulations cannot be ex post facto. They can't look backwards and retroactively change the legal consequences of past actions. That would be unfair. And so regulations look to the future. They're also directed at large groups and or overarching policy issues. So that makes regulations different from adjudications, which are hearings for individual persons, including organizations, and hearings are about a specific set of facts. So the definition on this slide is really the definition for a legislative rule, the type of regulation that is our main focus. So these are the regulations that have the force of law. There are also interpretive rules. These are usually found in guidance documents and agency manuals, and they are important. They tell the public how an agency interprets its mission and so forth, but they don't have the force of law. So keep in mind, you've already seen many legislative rules because we've gone over portions of the CFR. And as its name implies, the Code of Federal Regulations is absolutely packed full of regulations. So for example, Title 40 of the CFR contains the EPA's regs. Title 10 covers the Department of Energy. Title 18 is all about conservation of power and water resources. And Title 50 contains regulations related to fisheries and wildlife. So when people talk about regulations, or the lack thereof, they are usually talking about these legislative rules, the types of regulations that fill the gaps in statutes left by Congress. These are also what we are concerned with in this class, legislative rules. So these gap-filling regulations can be procedural or substantive, but both carry the force of law. So procedural regulations, as the name implies, they establish and implement a procedure, a process by which the agency plans to carry out its statutory mandate. And agencies have the implied authority to issue procedural regulations. So it's very, very difficult to challenge an agency's decision to create one or not to create one. Substantive gap-filling regulations, these operate just like laws. They reach into our lives and they require specific actions or prohibit specific actions, and they can impose penalties for non-compliance. Because these reach into our lives, Congress has to delegate authority to agencies to create these substantive gap-filling rules. But that authorization can be implied, so Congress doesn't have to specifically tell the agency to create regulations. Because these do impact our lives as well, they are easier to challenge in court. So we'll actually see later in the lecture, but it's normally very difficult to challenge agency inaction, but if Congress tells an agency to create regulations, then we can sue the agency if they don't carry out that congressional mandate. So now that we know the definition of a rule, or the definitions, we can define rulemaking. Rulemaking is the exercise of an agency's quasi-legislative authority, it's granted to it by Congress, to promulgate regulations. It is basically the executive branch version of enacting statutes. So in other words, rulemaking is the process by which agencies create regulations to implement a statute or otherwise carry out their statutory mandate. So during this process, agencies are trying to fill these gaps left in the law by Congress. And remember, Congress leaves these gaps intentionally, often because Congress needs the scientific and technical expertise from an agency to determine how to best implement that broader policy that Congress enacted when it passed a law. Now, agencies can't engage in rulemaking or create regulations willy-nilly. They do have to follow the procedures set forth by Congress in the Administrative Procedures Act. Additionally, agencies can establish extra procedures for their rulemaking, and if they establish those procedures, they must follow them. So it's not required that they establish them, but if an agency sets a particular set of rules, it's got to play by those rules. So now that we have defined rule and rulemaking, let's examine the actual process of rulemaking. So very basically, Congress enacts a statute. That statute tells an agency to create regulations. The agency takes some time to analyze the law, to understand the regs it needs to issue. It proposes a regulation for public feedback, and then it issues a final regulation. So that's the process at a very high level. But in practice, there are a lot of steps. So first, let's take a look at the steps that an agency has to engage in before it even starts drafting the proposed regulation. So first, agencies have to analyze the law, and they need to decide how to allocate their limited resources to implementing that law by issuing and then enforcing regulations. So in doing this, agencies have to evaluate the various problems. And I say problems plural because the agency has to solve the problem set forth by Congress, the one it's supposed to solve by issuing regulations, but agencies also have to look for future problems that might result from issuing a new regulation. Second, agencies have to evaluate their resources and decide how much time, money, and personnel are available, not just to draft the new regulation, which can take a really long time, but also to enforce it. And then third, once the agency has a resource allocation plan, it has to decide exactly what to regulate, where to regulate, when to regulate, and how to regulate. Only then can the agency actually move on and draft its proposed regulation. So let's take a closer look at this pre-drafting process as it relates to air pollution regs. If Congress instructs the EPA to issue a regulation regarding air pollution, the EPA first has to figure out exactly what that means. What does Congress want the EPA to regulate? The authorizing statute, it might not explicitly state a list of pollutants that require regulation, so Congress might be leaving this up to the agency. And agencies also have to consider re-regulating as we accumulate more data and as scientific tests are improved and refined. So it can cost a lot of money and it can take a lot of time for an agency simply to gather the data on impacts of chemicals and other forms of pollution. And one of the main reasons why is because in order to know how pollutants affect humans and other living creatures, scientists have to engage in research. So historically, this research has been done on animals, usually mice, but animal studies take time. They're not necessarily accurate for humans. What makes a mouse sick over time does not necessarily have that same effect in humans. Obviously, we can't experiment on humans. We're in fact prohibited by doing so without their consent. There's a federal common rule for the protection of human subjects. So we are left to gather data, and that might take many decades to yield useful information. So additionally, regulated parties engage in pretty fierce lobbying. They are prone to overstating the costs of regulation, and environmental groups are prone to overstating the benefits of regulation. But historically, we have found that benefits do outweigh the costs for major pieces of regulation, like the Clean Water Act's permitting regs. Okay, so once the EPA understands, or thinks it understands, what it should regulate, then it has to decide how much to regulate. Now the EPA just, it could ban all pollutants, but doing so would totally kill our economy. So the EPA needs to balance public health and other factors along with the economic pros and cons of regulation. But how do we even define public health? Pollution impacts different people in different ways. Do we regulate based on the healthiest people in society or the least healthy people? Does it matter if their health is based on purely external factors such as pollution? Or do we need to also consider lifestyle choices such as smoking? In addition, agencies have to determine if the statute requires them to take specific actions, such as testing contamination levels. Because if testing is required, then agencies also have to spend many years and many millions of dollars running and analyzing these tests. Sometimes they'll pass on the cost of those tests, or even the testing requirements themselves, to the regulated party. But in any event, it takes a while. And then agencies have to choose between regulatory options. If there's a potential toxin, should the government ban it outright or regulate it? If the decision is to regulate, what's the appropriate regulatory standard? And can it be applied fairly within the regulated parties with a fair result for both regulated and non-regulated parties, the general public? Now, every so often, Congress makes the decision for the agency, and Congress imposes what we call a zero-risk standard. This primarily occurs in order to protect the public health. Our textbook mentions the Delaney clauses to the Federal Food, Drug, and Cosmetics Act. These Delaney clauses, or Delaney amendments, they prohibit any unsafe additives in food, drugs, and cosmetics. And the Delaney clauses, they effectively tie the FDA's hands. They make things more difficult for food, drug, and cosmetic companies as well. But by passing them, Congress was making a moral statement, basically saying safe food, safe drugs, safe cosmetics, these are non-negotiable items. The public deserves to be confident in the safety of these items. This is a bright line standard, and that means that it can be inflexible and it can lead to illogical results. As the book mentions, the Delaney clause initially applied to processed foods, not to fresh foods. So consumers were selecting fresh foods thinking they were the healthier option, but they were actually eating more pesticide residue than consumers who relied on canned foods. So that's where it can get illogical. In many cases, Congress requires agencies to regulate basically to the degree that regulation is feasible. But again, what does that mean? What does feasible mean? Congress hasn't defined it. And so that leaves agencies to kind of muddle through. Feasibility standards can also cause arbitrary results, and they tend to be more dangerous to poor and minority communities, as well as to individual factory workers. And that's because questions of cost and benefit, they vary so widely. So feasibility always involves a cost element, and if it's too costly to comply, sometimes industry can get waivers. Unfortunately, it is usually the most contaminated communities that have the highest cost of compliance, so they might never actually get true remediation. So the town of Hinckley, California, which was featured in Aaron Brockovich, that's been called a ghost town, and this is decades after PG&E contaminated the land. And that's because it is simply too expensive to clean up. It is not feasible. The feasibility standard also, I should say, requires industry to cooperate with the government and to provide accurate, up-to-date data. Again, that's challenging to do, and industry does have a habit of pushing back on stricter compliance standards. Sometimes Congress requires the EPA to balance the risks and benefits of a product to determine the appropriate level of regulation. Unfortunately, that means the EPA has to make its best guesses about future risks and factor those into the balancing equation. This option, appropriate level of regulation, it also requires a pretty consistent reevaluation of products in order to be useful. Because as scientists gather more data, the EPA's got to be able to re-examine products that it once thought were safe if evidence now shows that they are not. And again, this type of option, it takes a really long time, in part because it takes so much time simply to collect the data. This makes regulating a more difficult task, and it leaves regulated parties in an uncertain position as they're trying to develop their product lines and market strategies. But wait, we're not done yet. Once the EPA answers the what and how much questions, it's got to determine where to regulate. People are different, environments are different, they both react differently to pollution, so where does the EPA start? What is the optimal point of regulation? As a side note, that doesn't actually matter because it's too expensive to find it, so we rely on proxy measures. But is it even possible to trace pollution back to its source? Do the regulated parties know the rules? Is the government really finding all of the regulated parties? So after figuring out what to regulate, how much to regulate, where to regulate, then the EPA's got to figure out how to regulate. So for instance, the Clean Air Act, that's a massive piece of legislation, and it has produced massive numbers of regulations. The Clean Air Act allowed the EPA to create our national quality standards for air pollution, but as we discussed, scientific uncertainty comes into play, especially trying to apply a one-size-fits-all standard to different ecosystems. So because of this uncertainty, the EPA's focused its regulations to protect the public health of human beings within an adequate margin of safety. So it issues regulations to protect the public welfare, which includes the environment and other species, and it also regulates to handle quality of life issues such as smog and other types of visible pollution. But deciding how to do so can be very difficult. So for the EPA, and every agency's process is different, but the EPA has determined that it's got two broad types of instruments available for policymaking. It can use traditional regulatory approaches, which sometimes we call command and control. These set specific standards across polluters, so everybody's meeting a specific standard. Or the EPA can use economic incentives and market-based policies that really rely more on market forces to correct for any harmful industry and harmful consumer behavior. So over the years, the EPA's process has favored these market-based options rather than a traditional command and control. These options can include things like marketable permit systems, like cap and trade, taxing pollutants as they're emitted by factories, which then makes factories, want to reduce their emissions, subsidizing improved technology to capture pollutants, or some combination of those incentives. And the theory behind this approach is that companies are going to reduce their emissions as long as it's financially valuable for them to do so. And cost savings to companies also tend to translate into cost savings to customers who purchase products from those companies. So overall, what the EPA hopes is that pollution will decrease, and also that will result in lower overall social costs of pollution. Now, the main disadvantage with market-based incentives is that they can be inappropriate for dealing with environmental issues that pose environmental justice concerns. So emission trading programs, as an example, could have an unintended consequence of concentrating pollution in socioeconomically disadvantaged areas. Sometimes we call these pollution hotspots. There are also voluntary initiatives whereby companies can work with the EPA to cut down on pollution. There are also voluntary and mandatory informational techniques to let the public know about certain information that impacts public health and welfare. So for instance, the Emergency Planning and Community Right to Know Act, which was passed in 1986, that requires companies that release a certain amount of toxins into the environment to report these releases to the EPA and applicable state governments. That law does not require companies to report on the toxins in its products or in its manufacturing process, but what it's releasing into the environment. And at the state level, California's Proposition 65, that requires public disclosures of both toxic releases and toxic ingredients in consumer products. So that proposition requires businesses to give consumers clear and reasonable warnings about chemical exposures. So this is what allows consumers to make more informed choices. It doesn't really punish the companies. It just requires them to be more transparent when required for public health reasons. And although Prop 65 is only a California law, my guess is you've seen Prop 65 warnings on things that you purchase. Because California is a very populated state, most companies don't want to lose access to California companies. And so California's been pretty uniquely positioned to get industry to agree to increased environmental standards. Okay, phew, that was a lot of information. And that is just on the pre-drafting process. After that, agencies can proceed with rulemaking. Now remember, agency actions can be formal or informal, and most agency action is informal. So if a statute specifically requires an agency to engage in formal rulemaking, the statute will say so. It actually will contain the magic words, I'm quoting here, on the record after an opportunity for hearing. Those magic words are not in many statutes because the vast majority of agency rulemaking is informal. It follows a notice and comment process. So once the agency has a proposed regulation, it's got to publish it in the Federal Register and allow for public comment. This notice and comment period is one of the really cool aspects of rulemaking because we, the public, can get very involved. I actually view rulemaking as our #1 chance to interact with the federal government. So some people would say voting, and voting is incredibly important. I urge you all to vote, but it only happens every 2 years at the federal level. The rulemaking process happens all the time. And rather than just cast a single vote, during the rulemaking process, you get to provide substantive feedback to the federal executive branch. Now, sometimes agencies get the public involved from the get-go. They will issue an advance notice of public rulemaking and listen to public input before they even start drafting a proposed regulation. Usually, though, we, the public, have a chance to provide feedback after the agency issues a proposed regulation in the Federal Register. The nice thing about notice and comment is that even though it's informal, the Administrative Procedure Act requires agencies to actually read and respond to public comments on proposed regulations. So the agency can group together similar comments and provide a consolidated response, but it has to respond to all the substantive issues raised by the public and explain its reasoning. And so it'll often do that when it publishes the final rule. There will be many pages prior to the start of the rule itself, or regulation, that actually has these questions and answers. So this back and forth between the public and the agency, it creates a permanent record that's really useful in understanding the background of regulation. So it's a lot like legislative history helps us understand the background of statutes. That's what this record does for regs. So after the agency reviews public comments, it prepares the final version of the regulation, and it publishes that in the Federal Register. It also has to publish information about the facts it relied upon when issuing the regulation. It's got to define any major policy areas that the regulation affects. And again, like I said, it has to include responses to public comments. And then the regulation becomes valid and enforceable 30 days after it's published, unless the agency agrees to withhold enforcement for a longer period of time. So particularly for really burdensome regulations, including regulations that require technical changes, agencies want to give regulated parties, be they individuals or organizations, extra time to come into compliance in order to be fair. This delay also allows time for a legal challenge to the regulation, which would happen through the courts. So compliance can be very complex and expensive, and again, this is why we want to give people enough time to get themselves into good standing before the agency starts enforcing. So I would be remiss not to at least mention that there are actually 4 types of rulemaking, but truly, plain old informal rulemaking is the default. Formal rulemaking, again, that only occurs when a statute uses those magic words on the record and after an opportunity for hearing. Agencies don't choose to engage in formal rulemaking on their own, and that's because formal rulemaking, it requires an evidentiary hearing, basically a mini trial with cross-examination of expert witnesses, hearing officer's opinion, the executive branch version of a court opinion. So as you can imagine, holding an evidentiary hearing is both expensive and time-consuming. So agencies don't do it unless Congress explicitly tells them to. So this is why agencies most frequently use the informal notice and comment style of rulemaking. That said, Congress or the president, but not the courts, can require agencies to use what we call a hybrid rulemaking process. In reality, this is still the informal notice and comment process. It just includes one or more added elements. Much like with Cylons, which I mentioned because I just finished a Battlestar Galactica binge, there are several models of hybrid rulemaking. Usually it is just the simple notice and comment plus 1 or 2 added elements, like a decision to hear oral comments in addition to written ones, or a disclosure of methodology used or data supporting the proposed regulation. There is a specific model, negotiated rulemaking, that we will discuss in a moment. There is also an exempted version of rulemaking, which is neither formal nor informal. It's exempt. That doesn't require any public involvement, but it's also only available for select issues, most often internal agency operations or foreign affairs. And those resulting regulations that are made by exempt rulemaking, they're not supposed to impact individual members of the public or organizations. Now, this hybrid model known as negotiated rulemaking, sometimes called reg-neg, you would think it would be neg-reg, but it's reg-neg. This is a very important model to environmental law. And that's because this form of rulemaking brings together groups of stakeholders with the goal of drafting a regulation by consensus. So agencies that decide to use negotiated rulemaking, they must provide a significant amount of both administrative and substantive information. And that has to include things like proposed committee members. Those committee members have to be drawn from a pool of impacted parties. They've got to provide proposed meeting agendas and so forth. Additionally, once that negotiating committee is in place, so that committee of stakeholders, the committee selects a public policy mediator to facilitate the whole process. And that whole process, the negotiation process, it typically takes between 6 months and a year, and it is open to the public. So agencies can choose on their own to use reg-neg. They have the discretion to engage in negotiated rulemaking, and the EPA does it a lot. So the EPA has found that rules made via negotiated rulemaking are more practical, they're easier to implement and enforce. I will post the EPA's RegNeg fact sheet in our classroom in case you are interested in taking a look. And then other agencies, like the USDA and OSHA, they also regularly use negotiated rulemaking. There are concerns that industry is able to dominate negotiated rulemaking to the public detriment. And it certainly is easier for large companies to participate in these negotiating committees. But honestly, I'm not sure that we need to be concerned specifically with negotiated rulemaking. Industry and special interest groups from all across the political spectrum tend to dominate the rulemaking process in general, so even the informal notice and comment. So there's reason to be concerned that the general public isn't as engaged, but I don't think that there's any additional reason to be concerned with negotiated rulemaking. Because agencies have to submit most regulations to the public for feedback, and because those regulations have the force of law, it is not always easy for agencies to revoke those regulations. The process for an agency to unmake or revoke a regulation is basically just the regular rulemaking process. Agencies have to go through all the same steps, particularly the post-drafting steps of publishing in the Federal Register and allowing public comment. The president cannot revoke an agency rule by executive order, but Congress and the courts do have some options available, which we will discuss in a bit. So why do we care about regulations and the rulemaking process? One of the biggest reasons why we should care about regulations is because most laws are actually regulations created by agencies, not statutes passed by Congress. So during the time period of the 114th Congress, for example, Congress passed 329 statutes. At the same time, executive branch agencies issued over 7,000 regulations, so that is a 22-to-1 ratio. And many of those regulations impact our daily lives, often without our conscious awareness of them. Additionally, regulations are especially important, obviously, to those of us who work in agencies and to those of us who interact with agencies because we feel the personal impact of them. Also, in our two specific fields of interest for this class, environmental law and all hazards management, our federal and state systems of regulations, they are really interwoven. It's layer upon layer of regulations that implement the policies set forth by Congress and the state legislatures. With that many regulations, sometimes they conflict and they create additional problems for an agency. So sometimes they work together and you get a beautiful tapestry of administrative law, but oftentimes it can be a tangled web of confusion. So I want to reiterate that regulations really do impact our lives, even though we might think of them only rarely, if at all. So here are but a handful of regulations that impact us, affect our lives or portions of our lives. 44 CFR section 206.35, that sets forth the process by which states can request the president declare an emergency. So for instance, after a natural disaster. 10 CFR Part 429 requires that commercial products meet certain energy conservation standards. Good for the environment, also good for the consumer because we pay less for energy. 15 CFR Section 200.107 requires NIST to set standard time intervals and issue time corrections. So NIST actually sets the official time in the US via its atomic clock, and it's authorized to do so via regulation. 50 CFR 26.32, that allows you to enjoy recreational activities at national wildlife refuges. We've got endangered species. 50 CFR 17.11 protects the Florida panther by listing it as an endangered species. Regulations even reach to safe drinking water in airplanes. 40 CFR 141.803 requires airlines to test their water for E. coli pursuant to the Safe Drinking Water Act. So we care a lot about regulations, because regulations benefit us as individuals and they can benefit society as a whole. And we'll talk more about that in a moment. But first, let's focus on how regulations benefit the law, sort of in general, and the federal government. So we already know that it is impractical to expect Congress to apply the level of expertise and detail required to carry out a law. And regulations give agencies the ability to do what Congress can't, which is add that expertise, scientific expertise, industry-specific expertise, also key implementation details. So many laws, especially environmental laws, require a significant amount of scientific or technical expertise, and it makes sense to let agencies add this expertise. They are, after all, supposed to be staffed by individuals who are experts in their fields. So take air quality again, for instance. It is challenging enough for the EPA to issue national air quality standards because even at a granular level, there is no one-size-fits-all solution. But it would be far worse if Congress, whose members are not knowledgeable about the science of air quality and air pollution, and are not knowledgeable about what's feasible for the industry, it'd be worse if Congress tried to set these standards. Fortunately, with regard to the Clean Air Act, Congress recognized this challenge, and it passed the 1990 Clean Air Act amendments, which actually allow the EPA to subdivide the goals of the Clean Air Act into smaller goals that are more achievable, and that allows the EPA to be flexible and pick up steam with regard to regulation. It lets the EPA adapt and make changes as we gain data and new scientific techniques. As we have also discussed, agencies are just inherently more flexible in regulating than legislatures are in passing statutes. Even though it can take a lot of time, agencies can still gather pertinent data, apply internal expertise, and issue regulations a lot faster than Congress can usually create a law. This is especially useful in responding to and adapting to rapidly expanding or changing environments and fields. And sometimes agencies are even innovative. There is a lot of really interesting research going on within most agencies, from industrial hemp at state departments of agriculture to some downright futuristic stuff at the Department of Energy and DoD. All right, let's jump back to benefits of regulations for society as a whole. So regulations can benefit society by preserving, to some extent, the public health and welfare, and that's both physical and financial. They also increase public knowledge, and they create consistency for regulated individuals and organizations. So our water's generally safe, our bank accounts are insured, our cars are more efficient, we know approximately how many calories are in a given food item, our businesses know approximately what's expected of them from a regulatory perspective, so they can plan for the future. These are generally useful things for society. So think about this. Back in the day, you had to be careful with space heaters. If they tipped over or if you left them on too long, they could start a fire in your home or, more likely, in your office where it is almost always freezing cold. So now, though, it's almost impossible to buy a space heater that can burst into flames. And that is because the U.S. government, via the Consumer Product Safety Commission, it monitors products for basic safety. No heaters that catch fire, no lead paint in children's toys, no baby seats that are dangerous in collisions, so on and so forth. And the Consumer Product Safety Commission estimates that regulations for cigarette lighters, cribs, and baby walkers, just those three things, save American consumers more than $2 billion per year, as well as prevent who knows how many terrible injuries. So what a lot of people fail to understand, and by people I tend to mean politicians and the general media, is that there are not just costs of taking action. So there are definitely costs of regulating, but there are also costs in refusing to act and refusing to regulate. And unfortunately, the costs of inaction are typically borne by the public. You get contaminated communities, lost lives, destroyed properties, lost opportunities. And there are environmental justice issues at play here. Many times, it's poor communities and communities of color that take the brunt of the costs of government inaction. That impact is usually unintentional, but it's still problematic on the ground. I live in a minority majority county, and unfortunately, I've witnessed this firsthand, especially in just the terrible environmental conditions in and around our public schools. But regulations aren't just good for society because they help people, they also provide a benefit to industry. Companies and other regulated parties that want to do the right thing for their customers, also for the society and the planet, they benefit from having an even playing field. So not providing that even playing field really amounts to a subsidy that favors these large multinational companies that care less over smaller national companies that might be more engaged in their community. So good regulations, they should allow good businesses to thrive by creating this level playing field, by providing a guarantee of consistency, and then by allowing companies to plan for the future. So sometimes pictures really are worth 1,000 words. So here are before and after photos of LA and Denver. And you can see how much the air quality in both cities improved between the 1980s and mid-2010s. And LA and Denver are especially prone to air pollution. They have frequent sunny days and low rainfall, which contributes to ozone formation. It also contributes to high levels of fine particles and dust. So smog builds up, but it can't dissipate because it is constrained by geological features, primarily nearby mountain ranges. So there are enormous benefits to the Clean Air Act and its implementing regulations. Even if we are not attaining the standards we want, we are very clearly breathing air that is cleaner than it was before. Here is another specific example of the benefits of Clean Water Act regulations. So Baltimore's Inner Harbor, it is a tourist attraction now, but it used to be absolutely wretched. Its beaches were full of trash. The Chesapeake Bay was heavily polluted. It wasn't safe to get splashed with harbor water, let alone do something crazy like catch and eat the blue crabs that hang out in the harbor. The Chesapeake Bay has a 64,000 square mile watershed that covers parts of 6 states and is home to more than 18 million people. So the Chesapeake Bay Foundation started actively encouraging the public to pay more attention to the health of the Chesapeake Bay via its Save the Bay campaign. And that's because, in part, the Chesapeake is really vital for Maryland's economy. Fishing and crabbing industry, recreational boating, tourist attractions, etc. Over the years, the Chesapeake Bay Foundation has used a combination of programs for the fish, crab, and oyster industries, as well as farmers and ranchers. It's used legislative initiatives, lawsuits, advocacy, and also public education. It issues environmental impact bonds to actually fund green infrastructure projects such as rain gardens and permeable pavement, and to generally bring Maryland into compliance with the Clean Water Act. So over the years, the Inner Harbor has improved so substantially that there's now an effort to make the harbor swimmable by the end of this year. I'm not sure that's going to happen, but a major part of that effort has been the Inner Harbor's water wheel, which runs on a mix of water and solar power. And so it's basically this water wheel that's got rakes attached to it and a conveyor belt, and it pulls in a ton of trash. This was actually funded as a public-private partnership. So it was a combination of efforts by the Maryland Port Administration, Constellation Energy, Baltimore City Department of Public Works, and some other organizations. And it attracted enough public attention that people started calling it Mr. Trash Wheel. And at that point, this public-private partnership decided to basically just attach some googly eyes to it and focus on public outreach as well as cleanup. And that's really important because by devoting some attention to public outreach, the public's actually become much more engaged. So the Port Administration, it allows the public real-time access to its camera systems so people can actually see what Mr. Trash Wheel is doing. Local news, they provide an assist by reporting on particularly odd things that Mr. Trash Wheel finds, like a 5-pound ball python. It was obviously a pet at one point, since ball pythons are not native to the Chesapeake Bay. It now lives at the Baltimore Zoo. Since it began operating full-time in May of 2014, Mr. Trash Wheel has collected over 1,000 tons of litter and debris. That includes over 1 million plastic bottles, over 700,000 chip bags, and over 11 million cigarette butts. In addition to the 5-pound snake, Mr. Trash Wheel has also collected a keg and a guitar. So operating the water wheel, it is about 1/10 of the cost of using skimmers to clean trash out of Baltimore's inner harbor. So this system not only relies on renewable energy, but it also uses a lot less energy than other solutions. And the wheel's design and the attention that it gets really provides a unique opportunity for public outreach and education that helps improve people's behavior. People realize that they shouldn't litter because it winds up in Mr. Trash Wheel, and the goal is to put Mr. Trash Wheel out of business. I personally am fascinated by government-sponsored research programs and as well as these programs from public-private partnerships. I think that they provide one of the best returns on investment for the individual taxpayer, as well as for our nation as a whole. And I wish that they all had effective public outreach like Mr. Trash Wheel. So for instance, a lot of people don't realize that the Department of Energy, research funded by it, has provided all of our digital recording technology that we use pretty much every single day. It has also provided modern water purification techniques. National Science Foundation research. We've gotten advanced electronics, new environmental resource management techniques, advances in nanotechnology. From the DoD, the Defense Advanced Research Project Agency, or DARPA, that gave us the internet, GPS, things like Siri and other like Google Assistant or Alexa. Economists actually estimate that every dollar spent at NASA pumps $14 into the US economy. So there's definitely like a financial return on investment, but there's also a quality of life return on investment. These are just a tiny sliver of benefits of government-sponsored scientific research. So how does the government tap into this scientific expertise when creating policies and regulations? Typically, agencies create science advisory committees to help. According to the GAO, these advisory committees really do play an important role in the development of policy and government regulations. It is important to understand that these science advisory committees, they do not make the policy. Their job is to explain what the science says about the likely consequences of policy choices. And then it's up to the policymakers to use that advice and actually make decisions. Policymakers often face situations ranging from epidemics to natural disasters to national security threats, in which the effective use of scientific information has a huge impact on public health and safety. And to meet these challenges, they need advice from independent scientists who can provide objective expertise, hence the science advisory committees. These committees are usually governed by the Federal Advisory Committee Act. That is a 1972 statute. It basically requires that the government properly manage these committees, keep a database. That database allows Congress to perform oversight. It also is searchable and available to the public. The Act also requires that these committee meetings are open to the public, and the committees have to keep minutes and other records. These science advisory committees, they are governed by official charters, which have to be renewed every 2 years. Those charters dictate their mission, procedures, meeting frequency, and so forth. Now, the committee members are often academic or industry researchers drawn from the tops of their fields. And typically, they don't get paid much, if anything at all, in return for this time and expertise that they give to the agencies. Primarily, the federal government just reimburses travel expenses. There are somewhere around 1,000 of these science advisory committees throughout the federal government. Just a handful. There's an advisory board on child abuse and neglect, an advisory committee on minority health, a board of scientific counselors for the Office of Public Health Preparedness and Response. The National Petroleum Council is one of these science advisory committees. There's the Rocky Mountain Resource Advisory Council, Committee of Scientific Advisors on Marine Mammals, and there's an advisory committee on nuclear reactor safeguards. So that's just a tiny handful. The EPA has 22 of these committees, but the most important is its Science Advisory Board. That board was created by statute in 1978, specifically to provide scientific advice to the EPA. Today, the board is made up of around 45 independent scientists. They are experts in their field, and they are selected by the EPA administrator to advise the EPA on the scientific and technical aspects of environmental problems. Unfortunately, in our current political environment, scientific research and advice has really come under attack. I feel that this should be a grave concern to everyone, regardless of political affiliation, for a variety of reasons. So first and foremost, scientific research, it's just a necessary element when it comes to solving complex problems, both natural and man-made. We need science to understand and hopefully reverse things like climate change. That's a big issue. But science is also crucial for more immediate and localized issues, such as natural disaster response, response to disease epidemics, things like that. Thanks to science, emergency planners have a lot more information on hand when it comes to predicting and mitigating the effects of things like earthquakes, volcanic eruptions, even epidemics like Ebola and now the coronavirus. So science is far from perfect, but the nice thing about it is that it's not stagnant and it's not invested in the status quo. Science changes, or should change, in response to newly discovered evidence. I firmly believe that science should not be political because it impacts all of us regardless of political affiliation. I work closely with research scientists. I'm at a university, and so of course a lot of these scientists happen to be more liberal, but I have worked with plenty of really conservative scientists too, who are absolutely dedicated to proper non-political science to help policymakers make important decisions. Unfortunately, it has become politicized in our current environment, and when I say current, I mean both the last few decades and specifically the last few years, which have been especially unusual from an administrative law and regulatory perspective. Just one example that affects science advisory committees: in June of 2019, President Trump issued an executive order requiring all federal agencies to evaluate the need to keep their current committees. And they also had to terminate a minimum of 1/3 of the membership of their committees, or 1/3 of their committees. Now, this is not the first time such a cut has occurred. President Bill Clinton, who is a Democrat, he made a similar cut in 1993, reducing any committees that were not required by statutes by 1/3. That was after a government-wide review of the federal bureaucracy. Trump's cuts have been more arbitrary, and they have not been the result of a government-wide review. As the New York Times article that you read pointed out, clashes over the use of science in policymaking, these occur in all presidential administrations, Republican and Democratic. But these clashes have grown much more dramatic during the Trump administration. One of these clashes comes from the proposed Transparency in Science rule, which specifically impacts the EPA. This rule would impact regulations that are crucial to many environmental laws, including the Clean Air and Clean Water Acts, Safe Drinking Water Act, Superfund, Emergency Planning and Community Right to Know Act, and the Toxic Substances Control Act. The proposed regulation requires the EPA to make the raw data behind its research publicly available in order to consider that research during EPA rulemaking. Unfortunately, this transparency in science rule reaches all the raw data, including things like individual medical records and other confidential information. The problem, of course, is that other federal laws prohibit the government from disclosing this type of data publicly. So because federal law prohibits disclosure, EPA researchers can't legally disclose their raw data, and under this proposed rule, if they can't disclose literally every piece of raw data, then that research cannot be considered during the regulatory process. Now, EPA Administrator Andrew Wheeler, he says that this transparency in science regulation is necessary because good science is that which can be replicated and independently validated. And he is absolutely right about that. We do need to check and double check scientific evidence, especially when it's being used to support regulations. But we already do that. This already happens. Scientific studies are generally not considered valid by the scientific community unless they can be replicated. What that means is this transparency in science rule is not really about transparency in science because that already exists for publicly funded research. It's more about shutting scientists out of the regulatory process. And this is why the EPA's Science Advisory Board has strongly pushed back against this proposed regulation. And remember, the EPA's board is composed of scientists named by Trump's two EPA administrators, so it's not like this is a liberal think tank pushing back. Members of the public and organizations impacted by EPA research have also strongly pushed back. The Transparency in Science rule has generated nearly 600,000 comments. That is possibly one of the most commented upon proposed regulations ever. So things don't look great, but not all is lost when it comes to the role of science in our current political environment. For instance, funding for the National Institutes of Health Research, that's actually increased during the Trump administration. Now, that's primarily been due to Congress, which, as we learned earlier, holds the purse strings. Congress has consistently funded NIH, but we have had a Republican-controlled Congress, so again, this isn't something that has to be political. So while I am incredibly supportive of the role of science in government regulations, and while I think regulations are generally a good idea, there are most certainly drawbacks to them. First and foremost, poorly drafted, poorly thought out regulations are, not surprisingly, a bad deal for all of us. Regulating for the sake of regulating is not appropriate. I believe regulations should be as clear as possible, as narrowly drafted as possible, and they should provide the best bang for our buck, both socially and economically. Second, regulations can create delays. They can add to bureaucratic red tape. They don't have to, but this is a legitimate concern. Sometimes the delays are due to the need to put the regulation on hold while the agency and regulated parties fight it out in court, but sometimes delays and red tape are kind of baked in to the regulations because of poor drafting, even because of confusion about what the agency was supposed to accomplish. Third drawback is that regulations can be costly for business. Agencies should attempt to make sure that these upfront costs will eventually result in benefits to the company and to society, but that is never guaranteed. However, on the whole, when we tally all of the costs of pollution, we actually find that the cost of regulating is far less than the cost of just allowing unchecked pollution. Now, in addition to being costly, sometimes legitimately costly, regulations can put companies out of business, and they can inhibit innovation. For instance, by scheduling industrial hemp, which has less than 0.3% THC, so if you smoke industrial hemp, all you'll get is a headache. But by scheduling that as a Schedule I narcotic for decades, the federal government has really held up important innovations in farming, ranching, textile manufacturing, and medication. And in that case, these regulations didn't just put companies out of business, it never allowed those businesses or innovation to get started in the first place. Now, on the other hand, regulations that are bemoaned by industry as, stopping innovation, they can have the opposite effect. There have been regulations that have really forced companies to create better products, which in turn attracts more customers to those companies. And companies that want to compete fairly for customers, they should be happy about regulations that enforce fairness and transparency. And that's because honest companies can't compete with dishonest ones. If a company is willing to be dishonest with consumers or not take into account the human cost of its products, then that playing field is not even. Another oft-cited argument against regulation is concern about creating a nanny state. And to an extent, yes, this should be a concern. We definitely don't want the government dictating our every action. However, again, many regulations, including California's Prop 65, these are now aimed at requiring disclosure rather than forcing companies to actually make changes to their process or products. So these regulations don't stop us, the public, from accepting risks or making bad choices. It just makes the terms of the deal clear so that we can make an informed choice. I know that it's not good to eat McDonald's. I still eat McDonald's, but given that I know how many calories are in it, I don't eat it every day. So yes, regulations can create a nanny state if taken to the extreme, but a lot of times they can also simply provide the public with information so that we can make good choices for ourselves. Now, because there can be drawbacks to regulations, especially ones that impact the economy or stifle innovation, there is always a desire for regulatory reform. Regulatory reform is often framed in political terms, but at its core, it is a neutral concept. As our government has expanded over the years, so has the tangle of laws and regulations. And not every regulation is good or necessary, and we shouldn't be keeping regulations that aren't beneficial to us. A regular review of regulations to catch and remove outdated ones, or to catch and remove regulations where the benefits haven't materialized, that's a good idea. And that was the point, in part, of the Regulatory Flexibility Act, a 1980 law whereby the federal government tried to balance socioeconomic goals of federal regulations with the needs and capabilities of small businesses and other small organizations. So the origins of the Regulatory Flexibility Act can be traced back to the general discontent about federal regulations that businesses have grumbled about, since the New Deal onward. But the urgency of these concerns did increase sharply as new federal agencies were created and as old ones were given new mandates to pursue, primarily in the 60s and 70s. So as a result of these concerns, as a result of the vast expansion of the federal bureaucracy, particularly after World War II, the Act requires the feds to solicit input from small businesses and other small entities, including nonprofits, and it requires federal agencies to seek less burdensome alternatives for those small entities whenever possible. A year after the Regulatory Flexibility Act, President Ronald Reagan signed Executive Order 12291, that required the Office of Information and Regulatory Affairs to review regulations that could have an annual economic effect of $100 million or more, and or could adversely impact the economy, productivity, jobs, the environment, and public health or safety. In 1993, the Clinton administration revoked Reagan's executive order, but Clinton replaced it with a very similar executive order. Adhered to the same principles. It even included that, review of any regulations with an annual economic impact of 100 million or more. Like Reagan's executive order, Clinton's order was premised on the idea that federal agencies should issue regulations only as required, basically to carry out their statutory mandates to protect the public health and welfare. Perhaps more importantly than those executive orders in terms of regulatory reform, in 1993, the Clinton administration launched an interagency task force called the National Partnership for Reinventing Government. That was headed by then Vice President Al Gore, and it really did cut through massive amounts of federal red tape. Its goal was to make the federal government more efficient and effective, and it overhauled a ton of really overly complicated regulations, including the entire system of regulations that govern federal procurement, but also health and safety regulations. A few years later, in 1996, the Republican-controlled Congress passed and President Clinton signed the Congressional Review Act. That act allows Congress to engage in an expedited review of any new federal regulations and allows Congress to overturn those regulations by passing a joint resolution within 60 legislative days from the date the regulation becomes effective. And if Congress overturns a regulation, the Congressional Review Act prohibits an agency from reissuing a substantially similar regulation unless specifically authorized by Congress. So if Congress overturns a regulation, the agency cannot re-regulate unless Congress tells it to by passing a law. So what this means is 51 votes in the Senate can repeal a regulation, because that's just what you need for a joint resolution, but 60 votes might be needed for the repealed rule to go into effect again, because legislation that would contain the second version would be subject to a filibuster. And this is why some people refer to the Congressional Review Act as the kryptonite of regulations. I want to make sure that you grasp this concept of legislative days. That is also important because Congress is not in session every calendar day or even every business day. So the Congressional Review Act gives Congress a pretty decent amount of time to review and revoke regulations. Now, until very recently, the Congressional Review Act was rarely used. It is a congressional check on executive branch agencies, and that is something that we want. But it wasn't used too often because it's not a really useful law unless there is a change of political control in Congress or in the presidency. And that's because presidents, as you might imagine, they're not usually willing to overturn one of their own administration's rules. And the Congressional Review Act, it requires a joint resolution by Congress, but it also requires the president to sign off on it. So Congressional Review Act is most often used as an attempt by incoming administrations to overturn the very last regulations of the outgoing administration. And that has certainly been what we have seen in the rollover from the Obama administration to the Trump administration. So prior to the 115th Congress, the Congressional Review Act was used successfully exactly one time in 1996, even though during this time, there have been over 73,000 regulations that could have been subjected to the Congressional Review Act. But the 115th Congress used it 16 times to roll back Obama administration regulations. As we read last week, it's especially been used to target environmental regulations. Perhaps the best known rollback was of the Stream Protection Rule. That regulation was in the works for over a decade. It was created based on massive amounts of input from scientists, industry, and the public. And the Stream Protection Rule sought to implement the Surface Mining Control and Reclamation Act of 1977. And it sought to do that by basically protecting the nation's waterways from the debris and general gunk generated by surface mining. When it proposed the rule and passed the rule, the Department of the Interior said that it would protect 6,000 miles of streams and 52,000 acres of forests by keeping coal mining debris away from nearby waters. Now, the Stream Protection Rule was far from perfect. For starters, it was 1,200 pages long, so right then and there it's not going to be a breeze to implement. But it was designed to balance environmental protection and the nation's need for coal as a source of energy. And it was generally thought to have as light an impact as possible on the coal industry. And it took 15 years of effort to get that regulation into place. And all of that effort, which includes an environmental justice impact survey of 286 coal-producing counties in the United States, all of that effort was wiped out by the Congressional Review Act. And since Congress revoked the Stream Protection Rule, it is now unclear how the federal government will implement the requirements of that Surface Mining Control and Reclamation Act, which again was passed back in 1977, so it's been a while. Another piece of regulatory reform is Executive Order 13771, signed by President Trump in February of 2017. This order created a task force and a regulatory reform officer at each agency, with the task force and that officer being responsible for combing through existing regulations to determine which ones need to be repealed or modified. So far, so good. As I said earlier, I think that should be standard operation within agencies. Unfortunately, Executive Order 13771 also requires agencies to repeal 2 regulations for every 1 regulation they create. This can basically cause us to find ourselves in a rather ridiculous conundrum. Do you want clean air or clean water? That's an absurd forced choice. It's just not always possible to offset regulations like this, or even to compare regulations from the same agency. EO 13771, that also requires the total incremental cost of all new regulations to be $0. That's a challenging goal because, like we said, eliminating a regulation, it triggers the same process as creating a regulation. Got to draft rules, public comment period, write the revocation, etc. So that right there adds a very time-consuming requirement for any new congressional legislation, and then the resulting agency regulation on a whole wide variety of topics, anywhere from banking to the environment to healthcare to labor laws to space exploration. Additionally, a problem with EO 13771 is that because of this, get rid of 2 for every 1 regulation, it ignores the fact that regulations are supposed to be issued and repealed based on scientific evidence, not based on the number of regulations. So even the Brookings Institution weighed in on this. Their tax and fiscal policy expert, William Gale, said that the total number of regulations, that's not the key. Instead, we should be looking at how onerous the regulations are. And so the Brookings Institution thought that EO 13771 was a nonsensical constraint, just because it's a very arbitrary number. Environmental regulation, as we know it today, really it's only been around for about 50-ish years. So when it comes to regulatory reform, we've got to learn from other fields, including financial field. Historically, we have not done a very good job when it comes to properly deregulating industries. So for example, in the financial realm, the US has gone through far too many boom and bust cycles as the federal government regulates and deregulates the financial industry. This started back in the 1800s during the gold rush. It continues up through today, when a lot of people are still feeling the impact of the 2008 financial crisis. So historically, looking at the field of finance and banking, something goes wrong in the federal market, in the financial market. Companies and individuals lose a ton of money. Government steps in to regulate. Market improves. People regain trust in it. Regulated parties start to complain about government regulations. The government deregulates, trusting the financial industry to police itself. The industry doesn't follow through on that. Once again, something goes wrong, and companies and individuals lose a ton of money. There is no reason that we have to keep going through these boom and bust cycles with financial regulation, and there's no reason that we should. And the same is true of environmental regulations. We effectively had none until the 1960s and 70s, particularly at the federal level. Suddenly, the government realized that industry was endangering public health and welfare, and so the feds began to regulate. But as things improved, companies started to complain about the regulations, government started to back off, assuming the industry would regulate itself. Sometimes that does happen, but often it does not. Petroleum companies like Exxon, for instance, they have admitted that they knew the science, they knew they were harming the environment, and not only did they not do anything about it, they actively hid the science, they hid damage from the government and the public. So as you've read, at least 95 environmental regulations, many of which are related to air pollution, have been rolled back or in the process of being rolled back by the Trump administration and Congress. But we don't know at what cost to our future. And like I've said before, we need economic and regulatory stability for the benefit of the nation, for its people, and also for its businesses. So I would say we really need to learn from history and expertise that we have built up over the years when it comes to regulating and also deregulating. We will discuss agency enforcement in greater depth later in the course, but I want to provide a brief overview now. So for federal environmental regulations and also all hazards management, enforcement is usually administered by the feds in collaboration with state governments. Sometimes the states are willing collaborators and partners. Sometimes they're more concerned with economic benefits to the state economy rather than environmental benefits for the country or world as a whole. To enforce regulations, agencies can serve administrative warrants. We'll talk about this later this semester. They can levy fines, they can adjudicate offenders, they can sue in court, etc. Agencies can also offer carrots along with the sticks. So for instance, economic incentives to produce less pollution. Agencies can provide those incentives, recognizing that we need continued economic growth, but we also need to protect the environment. So that's led to solutions like cap and trade, where companies can sell their unused pollution credits to other companies, thus creating this market-based incentive for companies to adopt better anti-pollution strategies. Agencies can also phase out pollutants or phase in regulations slowly to give industry time to adapt. This is what happened with unleaded gasoline. Our gasoline used to have lead in it. It was slowly phased out, and now we don't even think about it. We just expect that our gasoline is unleaded. Specifically for the Clean Air Act, Congress even authorized payments to coal miners who lost their jobs. So that was a way that they enforced the regulations, making sure that it was the companies that bore the burden, not the individuals. Now, it is very rare for environmental laws to compensate the losing side, but it can be politically and economically expedient to do so. Also, the U.S. judicial system reviews not only legislative enactments, but also the administrative decisions of many agencies dealing with environmental issues. So where the statutes and regulations end, the common law begins. And here's a saga involving the common law. So when it comes to enforcing regulations in real life, sometimes it can be easy, sometimes it creates a never-ending legal drama, and that's where we are with the FDA and its cigarette warning labels. So the Family Smoking Prevention and Tobacco Control Act requires that cigarette packages and ads have larger and more visible graphic health warnings. So not enough just to have the little printed notice that, you know, the Surgeon General says that smoking can cause cancer. Congress gave the FDA 2 years to come up with regulations requiring that these cigarette pack warnings have color graphics that depict the negative health consequences of smoking. So per this act, the FDA should have issued final regulations requiring these color warning graphics no later than June 22nd, 2011. And the FDA started well. It issued a proposed regulation in November of 2010 and a final regulation that was supposed to go into effect September 1st of 2012. A little bit late, but not terribly late. That regulation was based on a fairly extensive review of scientific literature, including the results of an 18,000 person study and more than 1,700 public comments. But this became an issue because the FDA actually never took action. In part, it didn't take action because of lawsuits, and in part, it was foot dragging. So on August 16th, 2011, 5 tobacco manufacturers, including R.J. Reynolds Company, filed suit against the FDA. They filed in the U.S. District Court for the District of Columbia, and they challenged that FDA graphic warning rule. And the tobacco companies argued that that rule violated their First Amendment rights because it was compelling their speech. And the District Court agreed. It struck down the FDA's graphic warning rule on a First Amendment basis. So much like the government cannot restrict our free speech, the government also cannot compel us to speak in a certain way, and the District Court found that by requiring these specific graphic warning labels, the feds were compelling speech by these tobacco companies. The FDA appealed the District Court's decision, but the DC Circuit Court affirmed. It was not a unanimous decision, but the Circuit Court did affirm. And the appeal dealt mostly with the actual images the FDA selected. And again, it focused on the idea that the government can't force us to speak in a certain way. The government does have more leeway under the First Amendment to regulate commercial speech, but the DC Circuit Court held that the FDA didn't even meet the Administrative Procedures Act requirement to provide evidence that these graphic warning labels were going to directly help the FDA meet its goal, which was to reduce the number of Americans who smoke. The court sent the case all the way back to the FDA, told them to come up with warning labels that would pass the free speech challenge from tobacco companies. And the FDA decided not to appeal that circuit court ruling and instead said that it was going to issue a new regulation about warning labels in about a year. Meanwhile, at the same time that the R.J. Reynolds Company was winning in DC Circuit Court, the FDA won a case in the Sixth Circuit. There, the Sixth Circuit Court of Appeals found that the FDA was legally obligated to implement some type of graphic warning. Now, typically, the Supreme Court will take a case if there is a split in circuits. And here there is, because we've got the DC Circuit and the Sixth Circuit reaching different decisions. The Supreme Court refused the tobacco company's appeals back in April of 2013, meaning the FDA was stuck. Should it issue the warning labels as required by the Sixth Circuit, or go back to the drawing board as required by the DC Circuit? Because the FDA refused to follow through on issuing a revised regulation, in 2016, a group of organizations, including the American Cancer Society, American Academy of Pediatricians, American Heart Association, American Lung Association, and a number of doctors, sued the FDA in the U.S. District Court for the District of Massachusetts. Those plaintiffs took a different tactic. They alleged that the FDA was unlawfully withholding action, basically by not issuing graphic warning labels, and that the Administrative Procedure Act allows the courts to compel that action, because under the APA, federal courts can compel any agency action that has been unlawfully withheld or unreasonably delayed. So the plaintiffs in this case contended that the original law gave the FDA 2 years to create a final rule. There's no reason it should take 4 years just to pick the photos. Additionally, the plaintiffs pointed to research that had been released in the years since the proposed regulation was issued. This research has indicated that the warning labels, had they been put in place in 2012, would have saved potentially millions of lives. So it took a while, but in 2018, the district court finally ruled that the FDA did unlawfully withhold and unreasonably delay its final regulation requiring these graphic warnings. The FDA told the U.S. District Court that it would finalize new warning labels by November of 2021, but the judge said that proposed date is a decade after the original deadline. The FDA's already unreasonably delayed action. She wanted the agency to present an expedited schedule. So where are the new graphic warning labels for cigarette boxes? In August 2019, the FDA finally issued another proposed rule on these required warnings. In November of 2019, the FDA extended the comment period with comments due by November 27th, 2019. The FDA's website update as of February 1st, 2020 still has the proposed rule up, but it has added the new graphic warning labels. But right now, I'm actually not really sure when we can expect a final rule. So it can be challenging to enforce regulations. And even when an agency is not unreasonably delaying regulations or unlawfully withholding enforcement, it is very challenging. And I think that's really clear, no pun intended, when you look at clean air and clean water. Because non-attainment of the standards of the Clean Air Act and the Clean Water Act, it remains a big problem. We've come a really long way. Obviously, from seeing those pictures of smoggy cities and now they're nice and clean, but the EPA still estimates that half of our rivers and streams and well over half of our bays and estuaries are not suitable for swimming or fishing. And part of the reason for non-attainment is that the Clean Air Act, the Clean Water Act, they did not necessarily get to cover some of these primary sources of pollution. For instance, agricultural runoff is a primary source of water pollution, but the Clean Water Act does not address it. So the Clean Water Act, the Clean Air Act required compliance with air quality standards by 1975. That obviously has not happened, although it's better. The Clean Water Act sought to eliminate all discharges of pollutants into all of our waterways by 1985, and clearly that did not happen. I live near the Anacostia River. It runs through Maryland and parts of DC, and then it empties into the Potomac. And in the summer of 2018, for the first time ever, the Anacostia got, and I'm quoting here, a passing grade on its annual health check. And that annual health check assesses levels of toxins, trash, and other environmental issues. Well, that passing grade was a D, which to me is actually not a passing grade, and for this class would not be a passing grade. But still, it's the cleanest that the Anacostia has been in many, many decades. And the various cleanup efforts resulted in much improved water clarity. We can actually see the bottom of the river by us. Less trash, way better regrowth of submerged aquatic vegetation. So a lot of that's really coming back, and the whole underwater ecosystem is returning. So we've come a long way. but these laws don't and really can't cover all sources of pollution. Like I said, Clean Water Act doesn't really cover agricultural runoff. Clean Air Act doesn't consider air pollution's impact on water. So it's difficult to enforce, but even some enforcement is clearly better than no enforcement because we're seeing the benefits right now. We still have to work on environmental justice issues. I really do think that's the big thing in environmental law right now, as people start to realize that the clean environment is good, but we can't force only small, poor minority segments of our communities to actually take on the burden of that. We've got to be able to share that burden. Okay, that is it for this week. In terms of the lecture, you do have a discussion due. I want to hear what you think about the role of science in policy development and how the government can do a better job at educating the general public about this role. Thank you as always for listening, and I will see you on the discussion boards.